The nursing home crisis. Important facts every retiree should understand about Medicaid, extended care expenses, and preserving family wealth. Many Americans spend decades believing that after years of employment, paying taxes, supporting families, and contributing to their communities, the healthcare system will automatically protect them during retirement if a major medical emergency occurs. Unfortunately, many families later discover that long-term care in America operates far differently than they imagined. A stroke, dementia diagnosis, neurological disease, or severe health condition can generate costs that rapidly destroy retirement savings. In many regions across the country, nursing home expenses now exceed $10,000 per month, while the regulations connected to Medicaid qualification, asset preservation, and estate recovery remain deeply misunderstood. This discussion is not about panic or political conspiracy. It is about learning how the system truly functions, so individuals and families can make informed decisions before a crisis suddenly appears. The purpose of this conversation is education, helping retirees and their loved ones better understand long-term care planning, Medicaid regulations, common misunderstandings, and why proper timing matters when protecting assets legally and responsibly. The financial reality of long-term care. Long-term care has become one of the greatest financial dangers facing retirees today. Many individuals spend years preparing for retirement income, investment strategies, tax planning, and Social Security decisions. Far fewer prepare for the possibility that they may eventually need help with ordinary daily activities. Those needs may involve bathing assistance, dressing assistance, eating support, mobility help, medication monitoring, memory care services, or 24-hour supervision. Once someone begins requiring ongoing custodial assistance, the costs can become staggering. In many states during 2026, assisted living facilities may range from $4,000 to $8,000 monthly. Skilled nursing centers may range from $9,000 to $15,000 per month. Specialized memory care facilities in major metropolitan regions can exceed $15,000 monthly. A stay lasting multiple years can easily consume hundreds of thousands of dollars. That reality surprises many families because they assume Medicare will continue paying indefinitely for these services. In most situations, it will not. And Medicare versus Medicaid. The misunderstanding that damages families. One of the most common misconceptions in retirement preparation involves the difference between Medicare and Medicaid. Their names sound almost identical, but the programs operate in completely different ways. Medicare is primarily a health insurance program for Americans age 65 and older. It generally helps pay for hospital stays, physician visits, surgeries, rehabilitation services, prescription medications, and limited skilled nursing care after hospitalization. However, Medicare does not normally provide unlimited long-term custodial nursing home coverage. Medicare may temporarily cover rehabilitation after a qualifying hospital stay, but that coverage remains limited and depends upon medical improvement requirements. Once an individual mainly requires assistance with daily living rather than active rehabilitation, Medicare coverage often stops. This is the moment when many families suddenly encounter overwhelming financial pressure. Medicaid is a separate program jointly managed by federal and state governments. Unlike Medicare, Medicaid can pay for long-term nursing home care for qualifying individuals. However, Medicaid is means-tested, meaning applicants must satisfy financial eligibility standards connected to income and assets. That creates a difficult situation for middle-class retirees who may own a home, savings accounts, retirement investments, or other financial assets, but cannot realistically afford years of nursing home bills. Why? So many families feel trapped. A very common situation unfolds this way. An aging parent suffers a stroke, experiences rapid cognitive decline, develops worsening Parkinson's disease, loses mobility, or receives a dementia diagnosis. Suddenly, the family faces urgent medical decisions. At the same time, they discover Medicare coverage is limited, long-term care insurance may not exist, nursing homes are extremely expensive, Medicaid regulations are complicated, and asset transfers can create penalties. And all of this usually happens during emotionally exhausting circumstances. And families are attempting to make healthcare decisions while also navigating legal and financial systems they never fully understood beforehand. Understanding the Medicaid look-back period. One of the most important concepts in Medicaid planning is known as the look-back period. Most states apply a 5-year look-back window for Medicaid long-term care applications. This means Medicaid agencies review financial activity occurring during the 60 months before someone applies. The purpose is to prevent individuals from giving away assets immediately before applying for benefits. During this review, states may examine bank transfers, property transfers, gifts to relatives, major withdrawals, asset sales below market value, or ownership changes. If prohibited transfers occurred during the look-back period, Medicaid may impose a penalty period. That penalty can delay eligibility for benefits according to formulas established by each state. In ANAO, this is one reason timing becomes extremely important in elder law planning. And the common mistakes families make. Many families accidentally create problems because they receive incomplete or oversimplified advice. ANA 1. Common mistake involves adding children onto property deeds. Parents sometimes believe placing children on titles automatically protects the family home. In reality, this can trigger Medicaid transfer penalties, tax problems, creditor risks, divorce-related exposure, probate issues, and other unintended consequences. Another issue involves large gifts during retirement years. Helping grandchildren pay for weddings, tuition expenses, or home purchases is extremely common. However, large gifts made during the look-back period may later affect Medicaid eligibility calculations. Another major mistake is waiting too long. Many families begin researching Medicaid only after a medical crisis already exists. By that stage, planning opportunities are often far more limited because the look-back clock cannot simply be undone. And Medicaid estate recovery. Another subject many retirees do not completely understand is Medicaid estate recovery. And federal law generally requires states to seek reimbursement for certain Medicaid costs after the recipient dies. This process is called the Medicaid Estate Recovery Program, commonly shortened to MERP. Depending on state law and asset structure, states may attempt recovery from assets remaining in the deceased person's estate. And recovery practices vary dramatically across the country. Some states pursue recovery aggressively, while others apply more limited procedures. Some states primarily target probate estates, while others maintain broader recovery authority. This variation is one reason state-specific legal guidance becomes extremely important. Why state laws matter so much. And long-term care planning is heavily shaped by state law. Two families with nearly identical finances may experience completely different outcomes depending entirely on where they live. For example, Medicaid asset limits differ from state to state. Estate recovery procedures differ by state. Home equity protections differ by state. Trust treatment differs by state. Spousal protections differ by state. And because of these differences, generic online advice can create major damage when applied incorrectly. Proper planning must account for the laws of the exact state where the individual resides. The importance of elder law attorneys. This is where experienced elder law attorneys become incredibly valuable. Certified elder law attorneys focus specifically on Medicaid planning, long-term care planning, asset protection, estate planning, guardianship matters, powers of attorney, and trust structures. These professionals help families understand available legal strategies before emergencies occur. Most importantly, planning must be handled correctly. Poorly prepared documents or improper transfers can create serious unintended consequences. Medicaid Asset Protection Trusts. 1. Planning strategy some families consider is the Medicaid Asset Protection Trust, frequently called a MAPT. MAPT is generally an irrevocable trust designed to help shield certain assets from future Medicaid spend-down requirements when established correctly and early enough. Important concepts often include irrevocable structure, trustee oversight, timing requirements, look-back compliance, and limitations involving retained rights. However, MAPTs are highly technical legal instruments and are not appropriate for every family. They involve trade-offs and restrictions. For example, assets transferred into the trust may no longer remain under the direct control of the original owner. Timing requirements are critical. Incorrect drafting can completely fail. Tax consequences must be carefully evaluated. State-specific laws still apply. That is why qualified legal guidance remains essential. The value of planning early. One of the biggest lessons families eventually learn is that planning opportunities are greatest before health problems appear. When an individual remains healthy and mentally competent, more options generally exist. After a major medical event occurs, choices often become narrower. This does not mean families become powerless during emergencies, but proactive preparation usually creates greater flexibility. Even basic preparation can make an enormous difference. Important foundational steps may include updated wills, durable powers of attorney, healthcare directives, accurate beneficiary designations, long-term care conversations, organized asset inventories, and understanding state Medicaid rules. The emotional challenges families face. Long-term care planning is not only financial, it is also deeply emotional. Adult children frequently struggle with guilt, stress, family conflict, caregiver exhaustion, financial fear, and time pressure. Parents may fear losing independence, becoming burdens on loved ones, losing their homes, running out of money, or losing dignity. These emotions often lead families to delay conversations or avoid the topic entirely. Unfortunately, avoiding the conversation rarely improves the outcome. And families who address these subjects earlier often manage later crises more effectively. Why financial education matters. Many retirees spend decades learning how to earn money, but very little time learning how late-life healthcare systems actually function. That educational gap creates vulnerability. People may incorrectly assume Medicare covers nursing homes forever, their house is automatically protected, small gifts never matter, estate recovery rarely happens, or every state follows identical rules. Unfortunately, those assumptions are often inaccurate or incomplete. Better education helps families ask smarter questions, prepare earlier, avoid expensive mistakes, understand trade-offs, and reduce panic during emergencies. Questions every retiree should consider. Regardless of income level, retirees should think seriously about several important questions. What would happen financially if I needed nursing home care for several years? Do I fully understand the difference between Medicare and Medicaid? And are my legal documents current and updated? And has my family discussed long-term care preferences? Have I consulted with an elder law attorney in my state? And would long-term care insurance still make sense for my circumstances? Do I understand how my state handles estate recovery? Are my current asset ownership structures appropriate? These discussions may feel uncomfortable, but avoiding them does not reduce the risks. The bigger picture. The American long-term care system is extremely complicated. It combines healthcare policy, tax law, state regulation, estate planning law, insurance systems, and family caregiving realities. There are no perfect solutions. Every planning strategy involves trade-offs connected to control, flexibility, taxes, protection, simplicity, and costs. The purpose of understanding these issues is not fear. The purpose is awareness. And families who understand the system earlier generally make better decisions than families forced to learn everything during an emergency. And final thoughts. Most retirees are not attempting to manipulate the system. They simply want to protect their spouse, preserve dignity, avoid unnecessary financial destruction, leave something behind for their children, and maintain choices later in life. Understanding Medicaid planning, estate recovery, and long-term care regulations has become an important part of modern retirement preparation. Inana, but every family situation remains different. The right strategy for one household may be completely inappropriate for another, depending on health conditions, financial resources, family dynamics, state law, risk tolerance, and long-term goals. That is why education matters so much, and why personalized professional guidance matters even more. The earlier families begin learning about these issues, the more planning opportunities they usually have available. In many situations, understanding the rules before a crisis occurs can create an enormous emotional, financial, and practical difference for everyone involved. This material is intended solely for educational and informational purposes and should not be interpreted as legal, financial, investment, or tax advice. Medicaid laws differ by state and may change over time. Always consult a qualified elder law attorney or licensed professional regarding your specific circumstances.